I would now like to welcome Mr. TV Madhusudan for the next session that we have today, which is on the view from the patent office perspective and suggestions. Mr. Madhusudan is a former deputy controller of patents and designs, and he headed the Chennai patent office, in particular its chemistry wing, and also was the head of office for all the three branches of that office, which include patent office, the trademark office, and the GI registry. In the patent office, he was responsible for prosecuting the patent applications filed in the field of chemistry, including pharmaceuticals, and was also responsible for the disposal of pre and post grant opposition, and has used this experience to really speak on a lot of the academic topics that are related to this field. He currently works as an expert in the sorry. He currently works as the expert in prosecuting patent applications in India, USPTO and EPO, which, as we know, are the US patent offices and the European patent offices. And he specializes in prosecuting these patent applications across jurisdictions. He has been a seminal speaker and academic, and has delivered talks at various universities across India and abroad. He was also the official delegate from India during the 16th session of the Standard Committee on Law and Patents, which was held at Geneva, Switzerland. Sir is also responsible for prosecuting the patent applications, as I mentioned before, in the chemistry field. And so as I see already, there are certain questions which have been directed towards Sir in the chat already. So I'll just ask Sir to come on board, probably switch on his camera and start with this session today. Sir.
Thank you very much. Mr. Shekhar, thank you very much for the introduction, and I'm thankful to the organizers for inviting me and giving an opportunity to share my views with the patent system, especially with the Indian patent system. So I like to share my presentation, and straight away we'll go. You were telling that there are some questions. Before starting the lecture itself, there are questions. Good. Let me complete my 1 minute.
So people are so excited for your talk that they've already started putting questions to you.
So what should I do now? Should I take my session first or take the questions first?
Absolutely, sir. I'll put the question to you later once the session, once you're through with the session. Yes.
Okay. I hope my window is visible to all of you.
It is, sir. It is.
Yeah. Thank you. Now, let me quickly go through what exactly. Now, the topic is IP issues in the post-COVID world. Views of the patent office. That is about my topic. Now, whether the COVID is there or not, there are inbuilt provisions are there in the Patents Act itself. One is that is the strong compulsory licensing system. So now I will elaborate when the particular slide pops up in my lecture. Okay. So compulsory licensing. This is a very the two words which are put side by side. Compulsory licensing. They contradict each other. The license means when as a patentee, when I want to give a license, that is my will and wish under which agreement I make and everything. And you are telling me to give license on a compulsory basis. So what is this nonsense? That is the beauty of the Patents Act. So whenever there is a requirement, the government may insist. Of course, there are various procedural aspects that I will not be discussing much. That is not the topic now. So there are so many aspects or points which are related on how to deal with the compulsory license system. But compulsory license system gives, or is it a provision wherein the government of India intervene and give the license to the competitor companies to manufacture the product which has been already protected by the patent system. Okay. Now, section 92 is a very special provision to grant under certain circumstances. So here also, now this 92 and 92A are also related to compulsory license, but these are exclusively for, see, now if I take 92, it is open to any area of technology. Okay, so I will discuss when that slide pops up, actually what are the circumstances. And section 92A is specific to the pharmaceutical medicines and drugs. That also for the circumstances which are different, under which the government of India can give the license to export the pharmaceutical products of section 92A. And section 47, there is a provisions right of government to import medicines and drugs for its own use. So now a patent holder is having a patent in India. Others are not allowed to manufacture or sell it or import it. But government of India, they have a right to import it whenever their need arises. So those needs we will discuss later if required. And under section 102 also, the government of India can acquire the invention by central government and for public purposes or by paying royalty. So I was listening to somebody was asking about secrecy directions. So secrecy direction in which way it is helpful to the applicant. Here, let me say here, suppose an inventor files an invention which is related to the prejudicial to the defense of India, then the Indian government claims secrecy and makes or directs the applicant not to disclose anywhere, and you also don't manufacture it. I don't require, but you help me. I will practice the invention. I will use it for our defense purposes. Definitely, since your right is infringed, your patent is infringed by the government, you should be compensated. So the government of India will pay the royalty to you. You may be earning less, okay, but that is not at the cost of the safety of the country. Therefore, this is one particular point. And then I'm not actually talking about patents law, because the latest topic which has been coming in newspapers and other discussions about the patent waiver with respect to COVID therapeutics. Now, before going that, just I want to tell you one particular point. What is patent? The basic question comes in here. What is patent? Whether patent is a scientific tool or a commercial tool. This has to be differentiated. Now, some people say it is a scientific tool. Why? Because the person who makes some advancement in the state-of-the-art technology, he goes to patent office and submits his invention, and patent office will publish it at the expiry of 18th month, right? So when it is publicizing, then it comes into public domain. At the expiry of 18th month, patent is not granted. That is, patent process totally different story now. I am not going to that. So at the expiry of 18th month, which is the international agreement that every country has to publish it after the expiry of 18 months, as soon as possible, it has to be publicized. When it is publicized, the inventor's provisional protection right starts. Because government is publicizing, its provisional protection starts. So after knowing what is that invention is about, then a person who is working in the same relevant field, then probably he may use it as his foundation and may try to improve upon, thereby contributing towards the development of the science, which is nothing but development of the country. You can talk about economic development or scientific development or self-sustenance of the government or India or whatever maybe you can say. These things, I'm sorry. So there is an improvement in the science. That's what I mean to say. So some other people say, no. Apart from scientific tool, though that we agree, but definitely each company to get more money or more income out of their own work, because patent right is a private right. It is not a public right. So when I own a house, I know what to do with that house, whether I demolish it or sell it or rent it, whatever it may be. It is totally my vision will. Okay. Similarly, when I have a private right, and that too, that right is for limited period, why can't I make quick bucks out of that? So I want to convert my patent as a commercial tool. So when I want to use this commercial tool, then that means when I am having a monopoly right over it, then I will start selling the product. If it is becomes the product is the most commercially successful product, then I can impose the price or whatever it may be. I want to do it. I can make quick money, quick bucks out of it. So some people say it's a commercial tool. Because of the reason, some people tinker with the small loopholes in the system and then try to see that they get more advantage. Okay, so that is also there. So therefore, no, when you are when you are thinking as a commercial tool, then probably the greed it may come into the, because human mind always have that feelings. Most of people have that mentality. Okay, I'm not blaming, but that is general mentality. So now, as a government of India, as a protector of the public, now I have to deal with two different interests. One is public interest, other one is patent's interest. I cannot say that one side government of India is giving a right to you, is a monopoly right, and allowing you to make money. So when other side, when I say I give compulsory license, for example, I am actually crushing you with some other law saying that you can't make money. So there are two contradictions here. Okay. So in such a case, now public is more important than the private interest. Okay. So I need to have a balance. When I need to have a balance, that balance is nothing but is coming in the form of a law, which is called patents law. Okay. So patents law is the balance of rights. Is actually patents law is related to balance of rights between the public and the owners, patent owners. So definitely in such a case, you cannot satisfy 100% of the either of the parties. Correct? Therefore, this is when the act is written, it is written in such a way that once you start reading the act, you will love it. Definitely, I will definitely say that. So, a lot of the permission commission thought about it, and it is drafted properly. Despite that, further improvements are definitely possible. The improvements can be made in the form of amendments. The amendments are made because that becomes a need of that particular day. Today, I need this amendment. Tomorrow, that amendment will become obsolete. I may have to repeal that. I may have to bring some more amendment. So any law is always open for the amendments. Okay. Now we are coming back to the most important point, that is health of the public. Now COVID has come. Some vaccines have been invented, and when vaccines are being distributed, the person who has invented a vaccine, he wants to apply for a patent. He wants to have monopoly right. He wants to make money out of it. That is his personal interest. Okay. Then the other side, government is thinking that I want to save the public. I don't want my people to die because of this. You please manufacture more quantities as far as possible. Stop other activities. Manufacture only this and distribute among the our Indian population. Or if possible, if you can make more, you can also supply to outside the country also. So that's how the government comes in. Since the patent system, since we know about there is an international patent system, wherein WIPO, we have a certain understandings and MOUs have been signed, etc., etc. So much of there. Therefore, to regularize globally, we are actually started fighting for patent waiver. So let me just quickly analyze what the patent waiver is about. Now, since it is not in the purview of the Patents Act, it's totally outside the Patents Act. Now, India has filed a request along with South Africa for a complete waiver. So what exactly complete waiver means? It allows all pharmaceutical companies in developing countries. See, now again there is a restriction. This complete waiver given to the developing countries, not only to make but also further down export vaccines without explicit permission from the patent holders. That means here I don't want to take any permission or license from the actual patent owner. Then I should be able to produce it. If possible, I should be able to export also. So that is what a complete waiver. So now EU has come out recently with a proposal. What they said, it is not a complete waiver for all the COVID, because now today we are having the pandemic with this coronavirus. Tomorrow some other pandemic may come out, maybe because of some other virus or some other bacteria. then how can we keep on extending for all the pharmaceutical companies or the theoretical candidates out of the patent this one that goes to basic, fundamentally not agreeable under the TRIPS agreement. So TRIPS agreement says that you have to treat all the types of all the technologies in this similar fashion. So you can't have a discrimination among the technologies. So therefore, medicines should not be discriminated. You could not say it should not be covered with patent. You don't grant any patent to any drug or medicine. Okay, so that should not be done. So the fundamentals are shaking by asking for complete waiver. Only for COVID you are asking, but it's not. Yeah, can you extend it further? These are the discussions. These are all in the discussion stage. Nobody has come to any conclusion. So the same discussions I'm trying to present before you. So you said, why don't we have only 5-year relaxation for COVID therapeutics? Now this is still pending. Now I have just taken about on the top I have given the link, just courtesy to that particular link, wherein it is written that waiver from certain provisions. These are actually, this is a letter from India and South Africa. This is a letter to the WIPO. Okay, and they're asking that under the TRIPS agreement, what are the conditions? See, if you look at the para 12, in these exceptional circumstances, we request the Council for TRIPS recommends as early as possible to the General Council a waiver from the implementation, application, and enforcement of Section 1, 4, 5, and 7 of Part 2 of the TRIPS agreement in relation to prevention, containment, or treatment of COVID-19. Now, I don't want to give any explanation with all these things. The gist I have shown you in the previous slide. That is the understanding. That's it. So the waiver should continue until widespread vaccination is in place globally and the majority of the world's population has developed immunity. Hence, we propose an initial duration of X years. That X years means that is to be filled up after discussions. Okay, from the date of adoption of the waiver. So now, what is the proposals they have made? That is the text what they have given. Now, this is a decision text of the same letter, which says that the sections 1, 4, 5, and 7 part 2 of the TRIPS agreement are to enforce these sections under patents of the TRIPS agreement shall be waived in relation to prevention, containment, or treatment of COVID-19 for so years from the decision of the General Council. The waiver in paragraph 1 shall not apply to the protection of performance. Of course, for other IPRs, it's not valid. So that's how it is. There are 5 points here. The decision is without prejudice to the least developed country members under paragraph 1. So least developed members are totally excluded. And waiver shall be reviewed by the General Council not less than 1 year. Now, whenever it comes to force, after 1 year, we will review it whether it's required or not required. And members shall not challenge any means. So it says that other members should not challenge what are the proposals what are being made here. So now actual problems, where the problems comes now. Few countries have developed vaccines against COVID. Okay, out of so many countries in the world, few countries are there. Now, India has played a major role developing manufacturing sufficient for our own use and export. These are the facts, correct? What are the facts in India? Patent waiver can be thought only after the grant of patent. When the question of patent waiver will come? Only when there is a patent grant. Now, in this session, somebody was asking, it takes so many years in getting the patent right. What will happen to the inventor? Whether he will get the incentive or not. So something I what understood maybe like that. So now, unless patent is filed, it takes minimum 2 to 3 years to get a grant. Once patent is granted, then whether you see whether even if the patent waiver is allowed globally, then can I do it? Patent waiver. At the time of filing, I cannot do it. First of all, we don't know actually how many companies have filed for patent in India. And all of you know very well, patent is a territorial grant. If patent is granted in the US or Europe for company X, they cannot access the right in India. So they should also file in India that particular patent for substantial same invention, and then they can get the patent right. That's a different story. So first of all, we should see how many companies have filed which type of patent applications, whether these are related to messenger RNA based or something else, some other technology based vaccines. Okay, there are so many varieties of vaccines technically. So what kind of vaccines they have filed, whether they are infringing with one another, or they have very difference of opinion. There's so many other things which has to be thought about. So India has played a major role. Patent waiver, we have to think only after the patent grant. As on today, no patent has been granted for the COVID therapeutics in India. It is as far as my knowledge goes. Probably I think I'm right, but it is subject to debate. If anybody is there to say that no patent has been granted for so and so, then uh, I may be wrong. But as far as my knowledge goes, there's no patent has been granted, at least to the multinational companies. There are so certain companies or individuals that simply filed some patent applications claiming some Ayurveda or traditional knowledge, basically they filed. But I don't know whether they got the patent right or not. I don't know. But still, patents have not been granted. Now, there is a provision called expert examination. For COVID alone, unless you satisfy the criteria which is specified for expert examination, you cannot get your application expedited in the prosecution. That is also not possible. So where is the question of thinking about discussing on patent waiver on this? Now, one more problem is there with Indian manufacturers. What is that? Even if a patent waiver is granted for 5 years, then how it will affect the Indian manufacturers? That is the big first question. In which way patent waiver has the effect on the Indian manufacturers? Indian companies not only develop indigenous vaccines, but also have entered into license agreements with global pharmaceutical companies. So already, because of the pressure, because of necessity, and because of the urgency, people said, okay, now you give me your technology, transfer the technology to me. I also will manufacture in this country. We will all put together. We will let us produce maximum so that we can save the people, or you can make some money as well. So that's how when the license agreement is made, license agreement is made for technology transfers. There is some royalty or compensation is involved. So once you have signed an agreement, unless there is a separate clause saying that this license agreement will be cancelled once patent waiver is evoked, then probably that license becomes null and void. So I'm not sure what type of contents are the license agreements. Generally, this type of thing may or may not. Generally, it will not be there. But if any clever lawyer who can think about the future, and probably they could have added, since it is a discussion, suppose patent waiver comes in, then I not take your permission, I can straight away produce it. So that all depends. So what will happen to that? More than a patent, it's the manufacturing know-how that matters. That is the part of trade secret. There's one more problem. There is in the patent, because in the patent you have 4 criteria to get a patent right. That is novelty, inventive step, and then industrial applicability, and then the statutory exclusions. Apart from that, it has to pass the requirements of Section 10. Even the Patent Act uses Section 10. Most of the controllers will ask the applicants, your application is not meeting the requirements of Section 10. I need full disclosure of invention. Still, there is a possibility on having some technology close to the chest without without disclosing the patent document. There can be something which will be kept into the as a trade secret. But if you really want to practice the invention, probably according to the patent document, you may be able to manufacture it. But profitable making, you may require technology transfer. That also may play a major role in these points. Now, what are the other inbuilt general provisions? Nature of applicants, you have a first category, natural persons, startups, small entities, and education institutions. And second category, who are not there in the first category, the remaining people are second category. Why these 2 categories? Because there is a fee difference. When you want to apply for a patent, you have a lower fee for first category and a higher fee for a second category. It is actually 1:5 ratio. Suppose you are paying 1,000 rupees as a first category applicant, then you have to pay for same application, 5,000 rupees if you fall on second category. And there is one more difference in the fee structure. One is you can do the physical filing or you can file through electronically. Okay. Now, when you file electronically, suppose there is a fees called X, then 10% of X you have to add to it and pay the money for the physical filing. If you are engaging a patent agent, then patent agent has no right to file physical copies. He has to file only electronically. Now, startup these slides just I will skip because everybody is aware what is startup and uh, because any small industry or any industry, in fact, you have manufacturing industry and service industry. There are two types. So under the startup definitions, what they have given, what is small entity and etc. So overall, this is the figure, latest definition of small entities. So you have the now that manufacturing services have been clubbed together. Okay. Now, if you look at the bottom, the revised MSME classifications, micro, small, and medium classification, manufacturing service are added together. Investment is less than 1 crore and turnover is less than 5 crore. And small is the investment is less than 10 crore and the turnover is less than 50 crore. And then for medium, investment is less than 20 crore and turnover is less than 100 crore. That's how it has been defined. Probably there could have been some other changes also. So now, whenever applicant changes from first category to second category, then the whatever fees difference they have to pay from that activity onwards. Now, education institute has been defined. Previously, there was confusion whether education institute comes in the first category or second category. Now that through amendment they have defined the added this definition. Education institution means a university are established or incorporated by any central act, a provincial act or a state, and includes any other education institution as recognized by an authority designated by the central government or the state government or the union territories in this regard. So these are the things. Now, under the amendment rules 2016, so these are the number of applicants up to, you can see here F. These applicants can file a expert examination request. So the applicant is a startup company, applicant is a small entity that comes under MSME, medium, micro, small, and a startup company, definition you have seen that if the applicant is a natural person or in case of joint applicant, the applicants are natural persons, then the applicant or at least one of the applicants is a female. If a lady is there, no, I mean, just I'm making fun here. Some applicants were just inquiring, sir, I want to apply for a patent. Once you apply for a patent, the publication section 11A happens at the expiry of 18 months from date of filing. Okay. So 18 months means 1.5 years. Then afterwards, controller cannot grant for a period of 6 months, even though if the patent is grantable for the particular invention. So 18 plus 6, 24 months, 2 years gone. Legally, you cannot get a patent right. But there is a provision of filing Form 9 and ask for an early publication. In such a case, it takes 1 month publication, then 6 months prohibition. Literally, the 24 months can be brought down to 7 or 8 months. That is also possible, provided if there is no backlog in the office. If there is a backlog, that time has to be added to the 7 months or 24 months. So some people say, sir, I want to get my patent at the earliest. I want right now. So people who are telling that there is the expert examination. So now I'm talking about individual inventors, not the company. So individual inventors, when they're asking, sir, I want to have a quick examination. Is there any other way? Then people jokingly said, you add your wife's name or a sister's name, somebody's name as one of the applicants, then you have get the right to file a expert examination. So the application will skip the queue and come in the front. So I'm just joking this point, nothing else. So, so that the applicant is a department of the government, and that the applicant is an institution established by central, provincial, or state act, which is owned or controlled by the government, or that the applicant is a government company as defined in class 45 of section 2 of the Companies Act. So all these applicants can file a request for expert examination. And also a person who is entering the national phase, that person also can ask for expert examination. That is also possible. I'll just skip this. Now, I will just tell about the sections which I was referring to. This inbuilt provisions to safeguard. Now, you see here, section 47. What it takes is may be imported. Now, any mission, apparatus, or other, you know very well, patents are related to product and process. Now, any mission, apparatus, or other article in respect of which the patent is granted, that is for a product patent, or any article made by using a process in respect of which the patent is granted, that means the process patent. So you are getting a product may be imported or made by or on behalf of the government for the purpose of merely of its own use. So now it is very clearly understandable saying that if invention is your any secret redaction is given to you, and here I'm sorry, here there is no secret redaction. I'm sorry, extremely sorry. Here, if a government wants to use for its own use, so generally what is for its own use? It is own use for the public use mainly. So if government wants and feels that there is inadequate production within Indian territory, they may get the imported. So it is grant of patents subject to certain conditions. So now, if, now COVID vaccines are there. Fortunately, India is exporting. But suppose India wants to import from other countries, the government of India can invoke this particular provision and then import the material products. Here we don't talk about any compensation. The government has to pay whatever, and moreover, since that product is whether patented or not patented, if it is patented also in India, and then they have to pay the royalty, or they may pay the whatever the exported rate. So any process in respect of which the patent is granted may be used by or behalf of the government for the purpose merely of its own use. It's the product and process. Now, last I say, now not only government can authorize a person. That person can also import, or a person for the purpose of performing only experiments or research, including imparting instructions to pupils, to students, to explain that, then also they can import. That will not come under the infringement. Now, section 47 continuation. In the case of a patent in respect of any medicinal drug, it's specific now, may be imported by the government for the purpose merely of its own use or for distribution in any dispensary. So government can import and then distribute through government dispensaries. That is about the section 47. Now section 102 is there. Here, acquisition of invention patents by the central government. Now here you can say the central government may, if satisfied that it is necessary that an invention which is the subject of an application for a patent or a patent should be acquired from the applicant or the patentee for a public purpose, publish a notification to that effect in the official gazette, and thereupon the invention or patent and all rights in respect of the invention or patent shall by force of this section stand transferred to be and vested in the central government. So government is completely taken over, and for that government will pay a royalty. Some royalty will be paid, or whatever the agreement that is made between the government and the applicant or patentee. At any stage, government can acquire the invention. Now, section 84. Now, what are the grounds for granting compulsory license? I was talking about government can issue license in respect of any kind of invention. It is not related to pharma field alone. Section 92A and 92 are related to mainly to the pharma. Here, the reasonable requirements of the public with respect to the patent invention has not been satisfied. Now, requirements are not met. Public demands 100 units a month, whereas India is able to produce only 75 units. So there is a shortage of 25 units. So in such a case, if some other company, competent company comes and tells the patent office, sir, I want to manufacture, but I went to the patent holder, he is not giving license to me, so I am coming back, and this is the proof that society needs much more than the supply. Then there is more demand than supply. Then government, if it thinks fit, then government may grant a compulsory license. And the next point is the patent invention is not available to the public at a reasonably affordable price. So this is a rider on the greediness of the patent holders. Okay, so you cannot sell. You cannot sell it in an unaffordable price. Of course, these are subject to a lot of discussions. What is unaffordable price? What is affordable? What is not affordable? This subject discussion, which I am not going into details. Okay. These are very subjective discussions. So somebody has to say that, sir, these poor people are not able to purchase that particular invented product or patented product. So therefore, that also has to be proved. And then patent industry is not worked in the territory of India. Somebody takes the patent right, but he will not work at all. Zero. Manufacturing is zero. Then in such a case, under three circumstances, people can apply to the government or to the patent office, and the controller of patents can issue the compulsory license. Now, section 92. So now compulsory license one point, same compulsory license in case of three circumstances where national emergency like COVID, in circumstances of extreme emergency. So in case of public non-commercial use. No, third point is not applicable for COVID cases. In the first two circumstances are applicable. So that is compulsory shall be granted. Say for example, company A in India has manufactured vaccine, and company B is having the capacity to manufacture, but because of patent they are not able to manufacture. Compulsory can be given. But all these conditions are only after the grant. Please remember that. So therefore I took the patent waiver first. Now, when patent waiver is not applicable, because nobody got the grant in India. And here also, when I say that compulsory is also post-grant provision. Okay. So when patent is not granted, even giving like compulsory license is out of question. The only thing is now under section 102, government can acquire even if application is filed, even though it is not granted. So there where I wanted to tell you here, under section 102, what is acquisition of inventions at the time of filing or after the grant also, government can acquire it. If a patent office says that there are certain applications which are meant for the COVID vaccine preparations, then government immediately can take over and ask many people to start manufacturing because there is technology available. Somebody has filed. So government has that right that they can definitely exercise it. Okay, but for compulsory licensing and the section 92, all these things comes out only after the post grant. That's why I don't stress much on this. But even the patent is granted, we have sufficient provisions to protect ourselves from the patent system. Now, in the section 92A is only exclusively for exporting the medicinal drugs, not selling in the India. Suppose the other countries who do not have the capacity to manufacture or who don't have the facilities to manufacture, to such countries, then generally they are called as least developed countries. So Indian company can manufacture, but Indian man says, for example, patent A is person A is the patent holder, and patent B is some other company, and as per the rights of the patentee, manufacturing itself is prohibited. But under section 92A, if the person B, who is not the patent holder, who has not sought any license from the patentee, or who has not sought any wants the compulsory license, okay, for export purpose only, not doing a market in India, then he can seek for a compulsory license. Then that person may be given depending upon the requirements under the compulsory license system. And now coming, now totally I'm shifting from what are the provisions in the Patents Act, and now what our topic talks about is what are suggestions you can give. What else suggestions can be given? What I say is, if patent is not been filed, then patent office is out of the scene. So unless no patent is filed under section 102, government can use it. Okay. So then what type of suggestions we can make generally in the common sense? I think we can't do any amendments right now, except asking for patent waiver at an international level. Okay. Now, with respect to the educating the people, you do it. There is DPIIT is having one division called DPAM, the National Intellectual Property Mission. So that particular division is taking care under the Azadi Ka Amrit Mahotsav, and they started teaching the students. This is exclusive to the educational institutions. And in each office, you have NIPAM senior team leader, NIPAM team leaders, and NIPAM officers. So now school children or college students have been divided into 3 groups: 8th to 10th standard, 11th to 12th standard, and degree students of any discipline, whether you are doing your CA or your engineering, that is the medicine, or it doesn't matter. Whether law, doesn't matter. Now taking the audience as a common audience, the scheme has been, syllabus has been prepared, and NIPAM officers and NIPAM leaders, they will be taking the classes on online now at present, and they're actually giving the exposure to the IPR system, and complete IPR, not only for patents, they're talking about IPRs. Now, government support to the applicants. Where the government support? Now we say that a lot of money we have to spend on the patents. So we talk about the incentives. Now, as Mr. Balwant said, the India does not have any law to incentivize the inventors, no doubt. But the applicants have been given with incentives. So probably, see, I don't blame for any activities. Why? Because different people have a different thought process people are having. Probably government would have thought the inventors and his employer, they have internal understanding. Why should I poke my figure there? Let them provide incentives to the inventors with the internal strategies. Let them have it. So, but whole thing is, whoever is the owner, according to the application, I will give support to that particular applicant. Let the applicant percolate the benefits to the inventor. Let me not intervene. Let me not put a condition. Probably that could have been thinking for not having any law to support the inventors. As of now, as I told you, it's all subject to amendments depending upon the necessities and everything, are to protect the rights of the inventors. And that is one way of thinking. Second way of thinking is the industry. Mr. Balwant Rawat has already said that the infrastructure is provided by the company. So company is giving the laboratory, they have separate R&D, and you are exclusively you are doing R&D work, and you are not sure about the output. Whether you work for 5 years or 10 years or 20 years, you are not sure of the output. So, but company is paying your salaries. So company may think that it is a monetary loss for the company. Since you are not, throughout your life, you have not done any proper research work, you could not get any patentable product or commercializable product. But then your entire salary and everything, perquisites, everything is a burden to the company. So therefore, company says that at the time of joining company, what they say is, if at all you develop anything, then you please say that whatever intellectual property you develop, that belongs to the company. Let us have employer agreement. Let us do it. So like that. So now coming back to the incentives to the applicants. So applicants includes inventors. Suppose individual inventors are the applicants, then that whatever the government is giving incentives, that is going directly to the inventors. Okay. Now, who are giving the monetary supports? MSME, Micro, Small, Medium Enterprise, Department of MSc, DS, Department of Science and Technology, NRDC, National Research Development Corporation, TIFAC, Technology, Information, Forecasting and Assessment Council, TBD, Technology and Development Board, and state governments. Now, I will just quickly complete this. Now, apart from that, Government of India is supporting the startup companies through a program called SIPP. Now, if a startup company files a patent application, since they may not be aware of the procedural aspects of the patent system, they may take the help of a patent agent. Those patent agents, no patent agent will do free of cost, no work. So he needs a compensation for that. That compensation is being paid by the Government of India to the patent agents who are filing the patent applications on behalf of startup companies. See, at the time of filing the application, 10,000 rupees. This is now patent, trademark, design have been divided. So for trademark is 2,000, design is 2,000. At the time of disposal of application, without opposition, 10,000 rupees. See, the patent agent is overall getting 20,000 rupees. But at the time of filing 10,000, and at the time of getting another 10,000, government is giving. And startup company did not pay. That means for startup company, it is free of cost. One is there is a fee reduction. Okay. One is there is a fee reduction, and that fee is paid by the startup company, but legal services are paid by the government. So what is now, as a startup company, you have to pay some 1,750 rupees as a filing fee. Actual filing fee is 1,750 for a startup. Okay. Now, this 10,000 is for technical assistance taken from the agent, and the agent is being paid by the government of India, not by startups. So startup company is getting a benefit even at the time of filing itself. Okay. Now, actually, in the other countries, the incentives are given not the time of filing, maybe a small amount, but on the commercialization of the patent, they are giving good amount. But unfortunately, we don't have that law here in India. So Indian government thinks that that is none of my business, probably. And MSME, see, they are giving assistance of domestic patent after getting the grant only. They are giving 1 lakh rupees. Now, I will tell you a small secret here. Now, MSME is have kept funds separately for patent holders. Unfortunately, how Indian nationals are not aware of the patent system. Similarly, individuals are not aware of the money which is lying there. So simply go to MSME after you getting a patent certificate. Go to MSME, just submit the that certificate, take 1 lakh and come out. The certificate showing service sufficient, you get 1 lakh rupees. Then what else you want? So mainly it is applicable for the individual inventors. MSME, they say that it is for individual inventors. So the strategy can be like this. If you start a company or MSME, let them file the patent application on the name of the inventor instead of by the name of the company, and they can get 1 lakh. Or people may say that 1 lakh is nothing. When I look at the commercialization of the product, I get crores of rupees. I don't want that 1 lakh, but I want to own the rights. If company thinks like that, then company can file on its name. So it's all strategy. You cannot simply have direct guidelines. Do like this, do like that. It's not like that. Similarly, if you are getting a foreign patent, you get 5 lakhs. Somebody may get doubt here. Sir, I am getting the patents in say 10 different countries. Can I get 50 lakh? Answer is no. So you will getting the only 5 lakh here. Okay. Now NRDC. What NRDC is doing? They organize training programs on IPR and provide services and assistance and guidance in the registration of copyright design trademark patent GI. For patents, they provide pre-filing services, pre-art search, patent filing support, and provisional specification support for further proceedings and post-grant. Even they will bear the cost of filing, and real technology transfer also done by the NRDC. But the only thing is, instead of all expenses are incurred by NRDC, but if your profits are coming, they will take some percentage from the inventors. Now, similarly, TIFAC is there. So what is the TIFAC is doing? The PFC, they have a division called Patent Facilitation Center. It is PFC has become a national referral point for information and guidance on IPR matters for the country through. Now, many state governments, they depend upon the TIFAC. Now, these people also, applications, IP applications are drafted through their panel of patent agents, and then cost everything is borne by the TIFAC. Okay. So apart from that, they are able to provide the training programs for scientists, all from the government sectors most probably. And because these are comes under the Department of Science and Technology, they are mainly concentrating on the government institutions, including academic institutions. Now, TIFAC has a special program which is called Women Scientist Scheme. So these people, TIFAC wants to support the women who are having a degree in science and technology, but because of some or other reason, maybe delivery issues, or maybe there is a break in their service, and the people are not employed yet after a certain age. So they say that they are recruiting the women, they are training them, and they are making to become the patent agents, or if they are able to get a job in any IP law firms, they can get it. So it is an exclusive program done by TIFAC. So now self-serve departments under central government. Now each department having their own inbuilt system in supporting the IPRs. Now we are having IPR cells in almost all the colleges and academic institutions. But here in the almost all CSIR laboratories, they have their inbuilt system. Now this is Department of Biotechnology. Now Biotechnology Patent Facilitation Cell, in short it's called BPFC. So what they do is they encourage their own scientists in their own department, and then they do all the works. That particular BPFC department is meant only for serving the scientists who have developed the technology and which they want to file the patents and all. Okay. Now, Patent Assistance Funding Scheme, BIRAC, Biotechnology Industry Research Assistant Council. There is one more unit is there, BIRAC, in the Biotechnology Department. So it offers to provide IP and technology management services to SMEs, startups, academia, and so this apart from the inside, they're coming out and they're helping the SMEs, startups, and academia. And BIRAC empanel technically competent, experienced, and financially sound IP and technology transfer firms who could provide assistance for patent search, filing, and drafting. So they do that. And further that, they do the reimbursement of our expenses towards IP expenses. And but that how much reimbursement is done, that will be decided by committee. That's what BIRAC is doing. So now Biotechnology Department is helping the scientists inside their offices, and also the startup companies, SMEs, and other small companies, the companies which are involved in the technological researchers. Okay, so these people are also helping. So you're now actually any company, if they really want to develop some invention and then take the incentives or supports, there are several ways of getting the incentives. But of course, you can avail only from one of the assistances only. You cannot take from NRDC, you cannot take from a TIFAX simultaneously. You have to approach only one, and then that person only will get it. Okay. Now DPIIT is there, Ministry of Electronics and Information Technology. Now they have their own division, IPR division is there. So they will help the not only the ministry but also their autonomous bodies like CCA, CDAC, ICRT, CMET, CAT, ERNET, ESC, Media Lab Asia, NAC, NILIT, NICSI in registry, Samir, STPI, STQC, and SAC, LDR. So all these bodies are there, they can take inbuilt. So you need not go to somebody else now for assistance. But of course, these NRDs and TIFAC people, where they're helpful to you. Now these inside departments, they're helping you financially, but actually patent searches and validations, patent validations, you can take the help of the evaluators. Okay. Now, SAP 80, the DPIIT is having one providing financial support to startups and MSMEs. So these people are also going outside and then helping the startups and MSMEs. So now what is the reimbursement? Reimbursement to a maximum of 15 lakhs per invention. See, that is the beauty. 15 lakhs per invention, the maximum amount which I have seen so far. Or 50% of the expense incurred in filing a patent, whichever is less. So that's 15 lakhs probably including the foreign filings. So foreign filings cost you much higher compared to India. So Indian fees are all peanuts compared to the foreign filing fees, etc. Now you have a defense. So similarly, the Defense Department also they have a IPFC. The IPFC means Intellectual Property Facilitation Center. So these people also provide IPR center, etc. They help the people. Okay. Now, if you come to the state governments, Andhra Pradesh, they have TASC, Technology and Innovation Support Center, and they mainly they have the IPFC at Visakhapatnam, and then they actually support for filing patents, designs, etc. Now facilitating access to international standard IP facilities. But here, I'm not very clear why AP Andhra Pradesh is not giving any financial compensation. Now, these Andhra Pradesh is having association with the NRDC. So probably under NRDC, they're getting the free services. Okay. Now, coming to the Assam, you see here, Assam is also having a patent information center, and they encourage their own people, state people. Okay. Now, government shall reimburse 100% of the actual cost, including filing fee, attorney fee, search fee, maintenance fee, etc., with a maximum limit of 1 lakh for filing in domestic and 5 lakh for the international patent. See, now we have seen the MSME, 1 lakh and 5 lakh. So same thing it is coming in. The Assam is also following. Now Bihar, the state will bear all costs associated with the filing of domestic patents and reimburse the filing fee awarded foreign patents. So a person who hails from a particular state, he can get either central fund, either assistance or compensation, or from his own state government also he can take. But he cannot take from both the state government and central government. That point you please remember that. So Chhattisgarh is depending upon the TIFAC and their rules. It's complete. Chhattisgarh is taking the support, and Goa is giving 50% reimbursement of the cost incurred by the startup concerned in fees and all other costs associated with the patent application. If the patent is registered successfully, subject to a cap of rupees 2 lakhs, and national patents and rupees 5 lakhs for international patents. So Goa is a little bit generous. Instead of 1 lakh for domestic patent, they are giving 2 lakhs. Well, of course, for foreign patent, they are putting a cap of 5 lakhs. And Gujarat is having a tie-up with TIFAC. And Gujarat, after not only having TIFAC, associated with TIFAC, but also they have the reimbursement policy, wherein eligible startups are the rate of 75% of the cost of obtaining patent. Somebody gives 100%. So this is like that. Then similarly, Haryana also having 2 lakh and 5 lakh. And then Himachal Pradesh is also having this TIFAC, this one. And then Jharkhand, similarly, 2 to 10 lakhs, here it is there. Karnataka. So most of the governments that are having their policies, different policies they're having, we are getting all the things here. Okay. Now, what I do is I'm just skipping the slides because nothing much there to discuss. You can see in non-government organization, FICA also doing the service, CA is doing the service, CA is doing refunding, but not FICI. Now, with this, I just conclude it, and then I just open up for any questions you have.
Thank you so much for sharing your insights, sir. That certainly gave us an inside view into how IP filing works in India and abroad, and how several states have provided a framework to incentivize innovation, so to say. So there was a question in the beginning of the session itself by Sumita Dasgupta, who asks about your viewpoints and solutions towards the Indian Patent Office's recent increased referrals to the Ministry of Defense in matters pertaining to foreign filing permission requests for national security reasons. So what do you think about such increased referrals in the present situation?
Increased referral in the sense, what happens now, now the over the controllers are sitting, if they get a doubt, the secrecy direction is very, very important for the defense of India. So if the inventions are pertaining to that, naturally they will take a referral and take the opinion. Taking opinion is nothing wrong. So there is an increase in number of referrals in the sense that means the inventions are related to that. That is only the answer. It is not that everything will be blindly referred. Yeah.
Got it, sir. Thank you so much for that answer. So there's also another question with regards to the state regulations, where Ambika asks that with the variation in state policies and support for patent filings, has any one state come above the rest in the quantity of patent applications filed?
Most of the states, they're having the relationship with TIFAC and NRDC. Okay, so we don't have any data like that. Which state is the state is not actually they're encouraging the people to file patents. At the time of filing patents, they are not giving incentive. After getting the grant only they are giving. So the applicants that are taking this from elsewhere.
Got it, sir. So also, do you think
Yeah.
that there is a particular state or a group of states which are providing, whose incentives are proving to be more effective, or who have brought in the necessary regulatory change to ensure that more filings and more successful applications can be made possible through those regulations?
Yeah, this is only the financial assistance they're giving. Technical assistance they're not giving. So if you want to encourage the people, you should be able to give technical assistance. Say, for example, before filing for a patent, as I told you, one of the criteria is novelty. Whether you can make your own search, whether your initial is patentable or not, because patent is open. So under what circumstances you get a patent right, you know about it. So you have to make a prior art search. You have to make it, and then you have to do it. That one, you can take an expert's opinion. But state governments are not providing any expert's opinion. But after getting the grant, they are giving the incentives through the cash. So it's incentives only by cash, nothing else.
Got it, sir. So, will it be right to say then that this criticism is sort of similar to the criticism that we have for our sports infrastructure, where we say that before a person gets an Olympic medal, they're not getting the right infrastructure that they need. However, once they win the medal, then they're given all sorts of incentives and cash prizes by the government and by. So, is that analogy right then, sir?
Gold medal is given only after winning the race. Before that, nobody can give the gold medal.
No, sir, that's not what I'm saying, sir. I'm saying that the infrastructure that is provided, the infrastructure is not there.
The infrastructure, why the government should provide? You actually see, government is providing, the central government is providing. There is no doubt about it. NRDC and TIFAC, they are doing the job. There is no doubt about it because you are not aware where from you have to get incentive. For sports people, Sports Authority of India is there. They are also maybe providing facilities. Recognition is different part, but utilizing the resources is totally belongs to the person who is interested. So infrastructure is there or not here, it is not like that. Infrastructure is available even in your own laptop. Sit down at home and browse all the websites. Free patent searches are there, including Google patents. You can make a search because you are the person expert in that particular field. So by looking at the prior art searches, you yourself come to know. Probably you may need a legal advice. Probably you may need legal advice. For that, doors are open. Like you simply walk into NRDC or TIFAC, take opinion, or you can take a patent expert's opinion, or you can take a patent agent's opinion. There are so many patent agents are there, so you can pay and get the service. Okay, now what you analogy is telling is just reverse. The government has to provide infrastructure and encourage you. Here it is not like that. You have to do it by paying. You get a legal service. No, you have to pay for it. So it is totally ulta what you are doing. You're telling me. Yeah.
Understood, sir. Understood. So, are there any concluding remarks that you would like to share with us today?
Concluding, not much concluding remarks. Now, what to say is, it is very difficult to propose any amendments because of the pandemic or COVID type of situations. Okay. So, patent tax is fully having all the provisions wherein we can take enough protection against any type of pandemic or any other situation comes in. Patent tax is having all these provisions. I have full faith in the Patents Act. That is sufficient. No more suggestions for that amendments. Yeah.
Got it, sir. Got it. So, if you have time for just one last question,
Yeah,
does
please
that
go ahead. Please go ahead.
Yes. So, sir, Sujata asks that in your opinion, is there any incentivization for innovation in pharma companies from the government, particularly in COVID times? So, I understand that you don't call for any regulatory change as such in the Patent Act, but do you think that the right incentives are being provided by the government, particularly in the pharma industry?
No, no. There is no, for doing work, R&D work, incentivization from the government is not there.
And do you think that there should be incentives then, sir?
That's what I told you. If at all government of India wants to provide any incentives for starting any R&D work, there should not be differentiation between drugs and other technologies. It should be universal for all the fields. The government of India will not do any differentiation like that.
Got it, sir. Got it. Thank you so much for taking out time to talk to us today, sir.
Yeah.
It was indeed a great learning experience. We, all of us, me including the panelists, me and all my co-hosts, have really learned from this experience. We thank you so much for joining in today.
Thank
We
you.
also hope that you continue being with us in the next sessions that we have. We have 3 more exciting sessions coming up after this short lunch break that we're going to take now.
Yeah.
So yes, so for all the attendees and for all the panelists, we're going to take a short break of just 1 hour, and we'll be back at 1:30 with another very exciting session.
It seems there is one more question.
No, sir.
Okay.
None of the question that I'm aware of.
Okay, fine. Okay, fine.
Yes. Thank you so much, sir.
Welcome, welcome.
To all the attendees again, we'll be resuming with our sessions at 1:30. So everyone's requested to please join back then. Thank you.